Terrence Bradley's back up.
Before I begin, I wanted to ask you if you wanted to clarify any of your statements that you made yesterday.
Go ahead and ask whatever you're going to ask, Ms. Merchant.
Answer that question, yes or no?
You initially became involved in this matter because you called me, correct?
Absolutely not.
I didn't call you.
No, it was through a third party.
I read an article that was on September 11th discussing how much you and Mr. Wade were handling the correct?
That is correct.
And you called me that same day and left me a voicemail on my cell phone asking me to call you back.
I do not recall that, but I do not recall that.
You don't recall that?
I do not.
So it's possible that happened.
I do not recall calling you after the article came out. I was shown the article, but I do not recall calling you after the article.
Can you tell us your phone number?
It's 334-717.
Wait, hold up. Why is that relevant, Ms. Merchant?
Because she's gonna.
Because I need to establish that his phone number is the one that all of the texts that he had with me.
Can you just ask him if he has texted you at some point? We can stipulate that as a matter of record. We don't need that on the record.
Okay, we don't have to put it in the record. How about this? Can I show him a copy of what he saved in my
Sure.
phone? Take a look at that and just verify if that's your number and your cell phone.
That is my number and my cell phone.
Okay, and is that also your email address?
That is my email
Okay,
address.
great.
So she's got the record that he
Separate
called.
judge. So after whether or not you left a message on my voicemail, the next day, we were all in court in front of Judge Harris on September 12th, 2023. And Cobb, do you recall that?
I do recall being in Judge Harris. Yes, I do.
And your attorney, B.C. Chopra, was there, and I was there, and another attorney, Burt Cohen, were there, correct?
Those people were there at the time. BC was not my attorney. I didn't realize I needed an attorney until I was subpoenaed.
But B.C. Chopra was there.
I'm going to object to the relevance of this.
Ms. Cross, as I see this line of testimony, much of it is I'm taking in response to the original, how we started off this whole hearing, that Ms. Merchant had no basis whatsoever to bring this and she should be sanctioned. And I think she's laying that out. Okay.
Yeah.
All right. Ms. Merchant.
Oops.
I recall it was in a conference room in the front. I don't know. I know you were handling a case in Judge Harris. I think I was speaking to Burt about a case and BC was there to speak to Burt about a case. Yes, I do recall that happening, but I can't recall who else was there. It was a regular court date.
That conference room, that's sort of in Cobb County, there's a conference room in front of it.
Correct.
And it's not a public room, it's sort of like a jury room.
Correct.
And it was the four of us in that room talking.
I don't recall if anybody else was there. I will say that I do remember at some point it was myself, you, BC, and Burt there, but people were coming in and out of the courtroom. So I cannot sit here and accurately say that somebody else wasn't there at the time.
We talked, and people could have come and gone, but essentially
Correct.
we talked for the better half of an hour.
No, it wasn't an hour.
And that's the only time we spoke in person about anything related to this matter, correct?
Correct.
And based on that phone conversation, I told you I had been submitting open records requests and I was going to continue to submit open records requests, correct?
Based off what phone conversation?
Based upon our conversation in court then.
Oh, okay. Correct. You said that you were doing some open records requests, correct?
Wild.
And based on our conversation, I told you I was going to do some additional open records requests.
They talked.
Which open records request are you talking about?
Just any, just asking if we talked about that I was going to be doing some follow-up to Fulton County. I can specify that.
Okay, because I recall open records requests being made for other things, and so I don't know which one that you're referring to.
At that time, we talked about getting, I guess it's called a county card and getting access cards and things like that for coming in and out of Fulton County for you, Mr. Wade.
Okay,
And
and
all of the access that you all have. to
yes,
the office.
yes, and you asked me, did I have an access card?
And you are the one that told me that you and Mr. Wade, or that Mr. Wade at least had an access card.
I told you that the three of us had an access card because we had a contract with the DA's office or the county. I told you what those contracts were and that we had an access card that will allow us to pick up the documents, go into a specific office and leave out.
So we talked about that badge access card and asking for that. I was going to ask for that, right?
Correct.
And then a couple days later, I sent you a text. And then when I say a couple days, so that was on September 12th when we had that conversation.
Do you mind if I pull out my phone? Okay.
On September 14th at 6:38 p.m.
This is Terrence Bradley, Wade's friend and former lawyer. Government asked for sanctions against Ashleigh Merchant for saying that they never spoke. She says, you never talked to him in person at all. Yeah, you did. Obviously, he just admitted that. So the government asked for sanctions for something that was clearly
And what day
false.
was this?
It was September 14th.
September 14th,
Wow.
correct.
And I sent you a screenshot of a Fulton County Open Records request I did.
Yes, and I said, wow.
They were talking a lot.
And then we continued to text.
Wait. And then you sent another text about a badge, and I did not respond. You sent another text about an entrance card. I did not respond.
You got all the text
You
right
sent
there.
another text about some other badges and with a circle around it, and I did
Judge,
not
Look
respond.
at the judge. Judge is
Okay.
going like this.
All right. Mr. Bradley, if you could just respond to the question asked and only the question asked.
That was
Thank you, sir.
actually, I have an additional
Okay.
thing I want to raise. Ms. Merchant provided some text messages
See the
that she
judge?
let us know that she was going to refer to. The text messages are inconsistent with Mr. Bradley's exchange as he apparently is reading it off of his phone. So if I could ask Ms. Merchant, is this a true, accurate, and complete? And perhaps we can see what's on Mr. Bradley's phone. But more importantly, I am going to object, understand the court's leeway about Ms. Merchant
Sure.
being able to establish contact based on previous statements made. But I'm concerned about going into the content of the statements without putting things in the buckets that I've identified.
Sure. And so am I, Ms. Merchant. I'm not seeing so much the relevance of it back and forth. I'm allowing you to establish, the contact that was made in line with the outline you provided me, and I think we're on track with that. Were you planning to tender these text messages?
I'm discussing them with him. Now, if yesterday he said we didn't text about this case. So if that was his testimony again today, then yes, I would show them to him to refresh his recollection or to impeach him. But Judge, their first part of their argument is foundation, is what I'm assuming. They're saying all of these. They're not all relevant. I can give you all of my texts, but they're not all relevant. And so they asked for screenshots. And so I took screenshots. If there's a way to submit my entire text history with Mr. Bradley, then that's fine. If they want us to read every single text, that's fine. I just don't want to be in a position where people are saying that I'm not.
Well, I also want to avoid the situation where you as counsel of record are having to lay the foundation and do that sort of thing yourself. So I don't know how much further we can go with this before we get into that. So
Well, I'm not sure what their objection is. So I asked him about one question and he read off
sure.
several.
Why don't we just go with your next question and we'll see where we go from there.
She says you want all my messages? No problem. I'll give you all my
But
texts.
so, and
Bradley, when you wait for her to ask a question.
I understand that, Judge, and I'm not
Well,
trying
apparently
to
you
dis-
don't, sir. Wait for her to ask a question and you'll have a chance.
Woof.
So
Woof.
I think what the last thing I asked you was about September 14th. So those texts that you're talking about, those refer to the issue that we're here today about though.
Some text did, yes.
And then you called me again on September 15th, 2023, and we spoke on the phone.
I do not recall that.
Well, I texted you and said I needed to call you back, and then I later called you back.
I'm not sure. I do not recall.
He forgot
Okay. And
all their conversations.
do you recall the following Monday?
Your Honor, I appreciate the question as it is on the form, and if the question is what she's going to read, I object to it even being asked out loud without knowing, number one, the relevance of it. If the witness is going to answer his source of information, and I feel like it is so inflammatory as to say out loud without knowing where Mr. Bradley falls on that. then
What's
I
this
do not object to
question?
the question.
Okay.
Why is it that we're not allowed to ask questions?
Yeah.
And then when the question is asked, there's an objection made either by the state or the lawyers for this particular witness. It appears that what the state likes to do is force us to tell you in advance every question we're going to ask before there's an objection raised. And I don't understand why they get to do that when we are obviously in the same position to say to them, tell us every question you're going to ask.
Yeah.
I realize it's a
Thank you, Steve.
but that can be the questions asked, state objects, chauffeur objects, and the court rules, but not being able to put it on the record because it's inflammatory or it's somehow prejudicial.
Yeah.
I don't think that, I'm just suggesting.
Sure. So, Mr. State, I'd agree with you in the general sense of things, but in this situation, Ms. Merchant offered to provide essentially her list of questions in advance, giving us a preview of what she's going to say. And that puts us in kind of a different posture in that respect, where we can actually have some sense of what's going to come out. But Ms. Merchant, I think knowing what your next question may be, since usually we don't have that opportunity, does it presuppose some knowledge on his part that we have yet to establish is inside or outside of privilege?
Well, the first thing, Judge, is I gave these questions so that we wouldn't be in a situation
Sure.
where we were objecting and having 4 different lawyers talk about privilege, confidentiality, every single question. So I was hoping that we would ferret that out ahead of time. So this is the first that I've heard that. that objection to question 18. I did give the state copies of them as well, trying to be completely transparent. I have to establish that
Shady.
his information, there have been statements in this court that I lied, multiple statements yesterday. I can't even tell you how many times that
Yep.
was said under oath yesterday, and that I did not get this information. And so I have a right to,
Which I've already said we can do and we can go over, but, and we've already started doing that. But the next question,
Is juicy.
as you plan to ask it, may presuppose again, some information that he has that we need to determine whether it's inside or outside of privilege. Is that right?
no, well, I don't believe so, no. I mean, if we're gonna talk about the privilege, I wanted to talk about it beforehand, which is why I gave all of these. I didn't know the state had objections on these questions to privilege.
Yeah, which is
If we're gonna
shady.
talk about the privilege, I'm happy to ask him the substance of the question, but that is what I'm getting objections for. So I'm trying very
Right.
carefully to craft something to avoid that, but
She
happy to
should have
just ask
objected
outright the
before.
question.
Right. I don't see a way around that, Ms. Cross.
Ask it.
I understand, Your Honor. I'm gonna do whatever you tell me to do. The problem in the context that Ms. Merchant is posing the questions is, this was our communication, this is what I asked you, this is what you told me, and here are these texts that are supporting it. I understand the court's ruling that based on how things have gone, if Ms. Merchant feels like she needs to establish there was contact and communication, then I don't have an objection to that.
Anna.
However,
Shady.
number one, the text message, the exchange that the merchant gave me is apparently not complete. And so I don't know, like, without making her a witness, how the state can, I think we're entitled to, if she's going to refer to text messages, we're entitled to an accurate representation of what those are. Mr. Bradley's looking at his phone and that's what he's got. He isn't under no obligation.
She's grasping right
Ms.
now.
Merchant provided those to us and I appreciate it, but I can't tell as I'm sitting here
It's incomplete.
to an incomplete or an
I don't have
inaccurate
it all.
citation if what she gave me isn't complete.
Here, look at my phone.
So a couple things come to mind.
Here, look at my phone. Here,
Um,
here's the whole thing. Scroll through.
One
it,
would be that
Anna.
anything the witness is referring to on the stand, counsel at any point has the right to inspect. And so if that's what you're asking for, Ms. Cross, then I think you have a right to do that.
And you
if
can
He
object.
decided to do that. The other is as I've seen it so far, I don't think these texts are coming in as substantive evidence, but more for impeachment, in which case extrinsic evidence would never be coming in to prove them up. And he either takes her answer or he doesn't. And that's how it works. So I don't see
Sorry, Anna.
the foundation issue or the completeness issue really playing into it as it comes to impeachment.
And so they asked me for the relevant screenshots. I took them. He doesn't have an iPhone. I can't download the entire text message history. I told them they could go through my phone. Like, I'm
Yeah.
hiding something.
All right.
Yeah, she's being
All
petty.
right, Ms. Merchant. I
She's being
think
petty and sly.
at this point, again, I don't see anything extravagant about the next question on his face. I think we need to deal with it as it goes. So
Let's
you can
go.
proceed.
Let's go.
Where I could get an affidavit from about the affair. And you responded, no, because you didn't think anybody would freely burn that bridge. Isn't that true?
If you say so. I mean, I don't.
You have your text if you need to refresh your memory.
Where can I get an affidavit? Because I don't want to burn any bridges. Like to hear that.
September 18th at 3:11 PM. You need to.
Yes, I do see that.
Can I get an
Then I
affidavit
asked
from
you if
you?
Chris Campbell knew,
No.
correct?
Wow.
No, you asked me if under oath he would testify.
I'm gonna object to the source of the witness's information about that, whether that's firsthand information or not. And Mr. Campbell, of course, has a privilege too.
Well,
I
since
understand.
Mr. Campbell hadn't even been brought in to this proceeding at all, I'm also wondering about just the relevance of asking questions about Mr. Campbell.
It's been objected that I'm not asking about all the texts and I'm selectively asking, so I'm trying to go through all of them. I would much rather just ask the very relevant ones.
Well, I have an objection to her asking.
Everything. We know, Anna.
I can't tell if the statements or the testimony provided is consistent or inconsistent without a complete set of this text exchange. And
You
it's
could have
not
looked through
clear
her
in the
phone.
text exchange what the source of Mr. Bradley's information that he's providing is. And so that
Ask him on
that
cross.
is, I'm
Sure.
struggling, and I know everybody else. is
And again, I think you're focusing more on the merits than the impeachment value.
Yeah.
Right. If the sole purpose this is coming in is under those grounds, then you being able to match them up word for word, I don't see that as being the necessary prerequisite. But as it relates to Mr. Campbell, he's not a witness yet. He hasn't come in. I don't think he's come up really at all other than passing and maybe the firm. So why don't we skip ahead to the next questions and you could always come back to that if somehow he has made an issue in this case.
That's great, Judge. I needed some clarity because the state is objecting that it's not full and accurate. I'm keeping things out, and then they're objecting that I'm putting too much in. So I'm just trying to avoid every question having an objection, Judge. So on January 5th, 2024, we had a text exchange where we talked about that I had discovered that Nathan took Fani on a cruise and a trip and paid for it with the business card. You told me you were on a plane home from Dubai, but you would call me as soon as you got home. Do you remember that?
So what I have is a text message from you saying, "Oh my God, Nathan took Fani on a trip to Nampa and paid for it with his firm."
Yep.
And you said, "Is he that dumb?"
Yep.
And I said, "Wow, I'm on a plane from Dubai, land at 3. We'll call you as soon as I land."
So that is accurate. That's what you told me.
That I will call you as soon as I land and wow.
Yeah.
Yes.
Yes, that is accurate.
And then you told me that you weren't surprised because they took many trips to Florida, Texas, and California.
They said they never talked. The state came out and said she should be sanctioned for making all this up.
Okay, so
Wow.
I don't have that, but I can show my phone, but I don't have that in my phone.
Deleted.
So the question is just, do you recall?
I do not
saying that,
recall.
Communicating that to me?
I do not recall.
All right.
Like
Do
deleting
you recall
everything.
telling me that it was when she had to move her daughter a trip to California?
I do not recall that.
Judge, may I approach the witness?
You may.
She's got the screenshot.
Yes, I see this.
Does it refresh your memory?
It does not. I mean, I see what's on the text chain, but you said this happened January 5th?
So now
There's no date and time stamp on that.
he already admitted to like this sequence. So like we're missing a couple things now. That seems a little weird, a little fishy. Yes, I agree. Yes, I said this. Yes, I said this. Suddenly it's missing. That's weird. How come?
Can I see what you're
Oh, yeah.
approaching the witness with, please? So is this the complete text chain?
That is the complete text.
Rule of completeness. You could have asked for
While we're
those.
looking at that, can I just ask you, did you delete any text messages?
Nice.
I-
Waiting for
I
that.
have several messages in the phone with you. I've never deleted. I mean, there are messages about family and my health and
Mhm.
things like that. You asked me to be on some panel. And so I think it's complete, but
Well, no, my question was, did you delete?
no,
any
I
text?
haven't deleted anything. No,
Okay.
I have not.
And I offered them to look through my phone earlier.
A long
They
time ago.
are
Yeah.
Welcome to.
You never provided it to us.
I said you need,
Your physical
You have it.
phone, you never provided it to us.
it's
All
the
right.
only phone I have, Judge.
They're the
Yeah.
worst.
I
Prosecutors are
understand
the
and I don't
worst.
want to keep popping up, but my concern, of course, is that these exchanges are just
The
two
worst.
lawyers gossiping about information. And I'm concerned about it coming into the record in this way. I understand impeachment is a thing, but if we could do it in a way that the substance of this gossip is not, that part is not impeaching.
You
The
said
contact is impeaching. So I,
I don't think we've gotten to that point quite yet, Ms. Cross, but you can renew your objection if you think we have. So right now, the sole thing that Ms. Merchant is trying to do is hand him an object to refresh his recollection again. So we'll see where we get with that.
they can't believe they sent all these text messages because they asked
And I
Terrence
don't
and he's
have
like,
any way to download it. He doesn't have an iPhone, so I don't know.
we didn't see your
No,
text
I'm
message.
sorry, the state scrolled through it, so.
Yeah, they
not
scrolled
right there
through it.
yet.
They probably deleted everything. Delete. Did you delete my messages, Anna?
Now I can't find it. So I'm gonna move on to the next question that I actually can find, and then I'll find that and come back to it.
I wonder if they deleted
I
it.
sent you a statement and said, upon information and belief, Willis and Wade met while both were serving as a magistrate judge and began a romantic relationship at that time. And you corrected me and say, no, it was in municipal court. Is that correct?
I think that's pretty accurate.
And is that based on your personal knowledge?
But what question, was it municipal court or when they first met or?
My question was, is this accurate? Upon information and belief, Willis and Wade met while both were serving as magistrate judges and began a romantic relationship at that time. And you wrote, no, that it was municipal court.
Mr. Bradley, just a second. Mr. Chopra has risen. Is any knowledge, if any,
If any knowledge of Nathan Wade and Fani Willis's relationship, romantic relationship beginning while they were both serving as judges,
Big question.
is any knowledge that you have from your own personal knowledge or something that was told to you in furtherance of legal advice?
I have no personal knowledge of when it actually happened. I was not there. I do not have any personal knowledge. So
Okay.
I would choose not to answer that question under 1.6.
Mr. Bradley, we made a distinction earlier
Yes, sir.
that it's a bit narrower than that.
Okay.
1.6 is.
I have no personal knowledge, Judge. I apologize.
Okay.
If you
And
were,
that's not a problem. The issue is attorney-client privilege. And so whether what you learned, if anything, was during communications with a client.
It was.
Okay. Ms. Merchant.
and was it any knowledge that you had as to
Ridiculous.
the truth of that statement? Was it told to you in furtherance of legal advice?
I'm going to object to that. If that statement is true.
That's how I,
And the witness has already testified he has no personal knowledge about that. So whether he represented at one point it was true or not true, he has no personal knowledge about that. So could not testify.
Whatever.
prior inconsistent statement, Judge, do it all the time. That is what the state
It's
does
not a
regularly.
statement.
They bring in, if it's a prior inconsistent statement of another witness, Judge, Mr. Wade
Which other
testified.
witness?
I'm
Okay.
sorry.
Okay.
Mr.
Mr. Wade
Wade
testified.
That their relationship did not start.
But you can't impeach him with a prior inconsistent statement that's privileged. And
No,
so
but
we're
it's-
still, we haven't gotten over the privilege hurdle.
The privilege hurdle we've gotten over with fraud on this instance.
Well, that's the first time you use that word. So if you want to make the argument of why that applies, you can do that now.
Yes, Judge, the crime fraud exception, it applies because of the crime fraud exception.
She's ready to go. She's paying.
Which crime and or fraud
Prepared.
was committed here?
So there's a couple different things, and I want to just address them both because he's raised 1.6 and also raised attorney-client privilege. For
a fraud on the
the crime
court.
fraud exception says the privilege doesn't apply. Essentially, if he has to keep something secret to allow a fraud upon the court to continue.
Yeah.
So we've got that. We've also got,
No, it has to, the legal communications have to have done in furtherance of a crime or fraud.
Which
How
was
has that
that?
been established?
Their
And what,
affidavit.
again, what crime or fraud are we talking about?
we're talking about perjury, lying to the court.
Yep.
In the affidavit filed last month.
Yep.
Yes.
And so what have you done to link the communications that he made maybe, I don't know, years ago to the affidavit filed last month?
It's proof of the affidavit being incorrect,
False.
being false. He's given
It
a
may
prior
be,
inconsistent
But the
statement.
legal communication has to be in furtherance of a crime or fraud.
Right, but he also can't protect. So, and I think it's more under,
So if he had no idea, an affidavit wasn't even going to need to be filed until a month ago.
Right.
And these communications and everything happened well before that. How is anything that they communicated in furtherance of that affidavit that they didn't even know would have to be filed one day?
it's been waived. That part's been waived because he filed the affidavit. So you can't file something that's false and then your lawyer know that it's false and then say, oh, well, privilege, my lawyer can't correct that.
Right. This guy can say there's a different
When he
date.
waives the privilege, and he waived the privilege. He testified about this yesterday.
Mr. Gillen.
Yeah, very quickly, Your Honor. Let's not forget how we started on this journey with the state getting up and making very serious allegations against Ms. Merchant. Asking
Sanctions,
for sanctions,
liar.
saying all of her representations were inaccurate. And now
liars.
they are doing whatever they can to block access to that information,
Yep.
which shows exactly what she said
Yeah.
was exactly the truth. What they're trying to do is they're trying to say to the court, the 100% accuracy of Mr. Wade's declaration and of his testimony. And by the way, please, Judge, don't let Mr. Bradley tell you
Yeah.
what he knows.
Yep.
Because what he knows is that this relationship, based upon what we see from the text and what we've seen in the context, would show that the relationship started before November 2021. So I think we have a waiver issue, and parenthetically on the issue of crime fraud, Your Honor. The issue about crime fraud is whether or not in any context, the communication would be not in furtherance of a crime at that time, but it could be for any particular crime committed by the client in the future as well. It doesn't have to be something that's being committed at the time. I will also note that when you look at the attorney-client privilege, the law basically says, look, this is a privilege which blocks evidence from coming in. And so in order to have that, they have the crime fraud exception, which is a very low standard once a prima facie showing has been made, which I believe has been done by Ms. Merchant.
Beautiful.
All right, let me clarify one thing, Mr. Bradley. When you testify to personal knowledge, does that include anything you may have seen, heard outside of communications with a client? When you say you lack personal knowledge, does that include anything you may have seen or heard outside of communications with a client?
That's correct.
Okay.
No knowledge at all.
And communications that were made, if any, that relate to the subject that you were asked to, were there any other third parties present that may have resulted in a waiver of privilege?
Come on, man.
Including texts.
Am I answering your question or her question?
Question.
Okay.
Is there any other third parties ever present with you and a client that would have resulted in a waiver of these privileges?
No, Judge.
Of course he's gonna say
I
no.
can't recall anybody being present. I mean, we ran an office. We had people around our office, but no, I can't say that there were other people present.
Did you ever receive any kind of a waiver from your client at any point?
I have not received a waiver.
And anything that you learned regarding the subject matter at all, if anything, was it in the course of legal advice, of receiving or giving legal advice?
He's going to say, yes, of course. All of it was. Force field goes up.
That's a
Gosh.
broad question, Judge, to answer because the advice was given and then
Bro talk and pro talk. Talked as
then you
bros,
have
talked as
interaction.
bros.
I mean, it wasn't, hey, this is for, to say specifically this was for that, or, I can't sit here and say that. So I don't know how to answer that question, Judge.
All right. I think here is what we need to do as I understand the law.
Make him
As
answer.
I find it, the crime fraud exception only applies when by preponderance we found that communications made in the existence of a relationship were in furtherance of a crime or the client at the time knew or reasonably should have known that a crime, the attorney was being used to further a crime. I don't think that's been established here. Maybe something happened afterwards and that's something that can be
Wow.
argued during closings essentially. So I don't think the crime fraud exception covers this. The objection is preserved for the record. Mr. Bradley has indicated also that anything he learned about this subject occurred during those communications. There's some
Lies, total lies.
uncertainty on that point.
Yeah.
And so in order to preserve the record, at the conclusion of the hearing, I think I can go in camera with Mr. Chopra and Mr. Bradley, and we can put in a sealed filing exactly what the extent of those communications were.
What a joke.
What they were, and those would remain sealed until some time if we're ever directed otherwise. However, at this point, the question, getting back to the question asked by Ms. Merchant, as asked, would be sustained on the issue of
Give me a break.
privilege, the premise. He may
What a
have
joke.
told you something, but it does not appear that there's any evidence that the client ever waived and allowed that information to be conveyed to you.
You need him to rebut
Next question.
Nathan Wade. What a joke. Okay, that was not good.
Thank you, Judge. We talked about Ms. Willis and Mr. Wade coming to and from your
Wild.
office and security details following them. Do you recall that?
Do I need to look at my phone?
No.
Or can I?
I'm just asking if you
Oh,
recall.
do I recall? I think I did, yes.
Do you recall security taking Ms. Willis to your office?
I do recall security detail bringing Ms. Willis to my office.
Do you recall approximately when that was?
I do not.
Was that on more than one occasion?
I remember 2 occasions.
Okay.
Yes.
Can you tell me about those?
I can't remember when they were.
Were they before she became DA?
So I don't know if she had security detail before she became DA. So if she was sworn in, or I don't remember the dates, but I do remember, I think she was DA.
Maybe during her transition team period? Was that?
No, it wasn't. She would have had to have been the DA, I think. And I don't want to go on, I think, but I do remember twice her coming to our office. Correct.
And she had a security team both of those times.
Yes, she has a security team with her.
Do you believe that it's a different security team than she has now?
I don't know her security team now.
Do you remember telling me that it changed at some point, her security team?
Yes, I think I recall saying that, yes.
And that the most likely people that could testify or had seen things about them having a romantic relationship early on would be the original security team.
Ah.
I don't recall saying that, no, but
So Fani fired her security.
Do you
'cause they
recall
knew.
talking to me about other people that might have known about their romantic relationship?
I recall.
Yeah.
He stood up. Objection. He already
Objection
recalls.
based on, we don't know the source. I mean, this is either based on privileged information or it's hearsay. Year one.
He's already testified to, then you need to lay that foundation. So sustained.
Did Mr. Wade ever ask to use your credit card to pay for trips?
Objection
On
on privilege. I mean, just still same thing.
just
Yeah.
asking him to use a credit card, how's that in the nature of furthering a divorce proceeding?
Because,
All right.
yeah, it's a cover up. Sit down. Everything.
I had a business card and we would use my business card.
Huh. Interesting.
I recall a trip, but
Yep.
I don't know if
Yep, you do.
that trip has anything to do with this case. So
Wow.
I do recall him using my card once.
Was he with Fani?
When was that?
I don't even know when that was.
And he paid you back for that trip in cash?
I can't remember how he paid. I think it was. I mean, I'm not certain if it was cash or a check. We routinely would use my card for filings, for whatever
Yeah, office supplies.
stuff with the office.
Yeah.
And so,
Yeah. Lunch
and
with the
so he
team.
would, whether he paid me back in cash or whether he wrote a check, it was paid back to the business card.
But this was the only time he had used it for travel.
I cannot recall. I don't even have that business card anymore,
Yeah.
but I do recall at least once for travel.
Yeah.
Yes,
That was when you were still law partners with him though, correct?
that is correct.
You did not go on that travel with him though, correct?
I did not.
Okay. And so he asked you to use your card for the travel.
Yes, I mean, I'm assuming
So it showed up on your accounts.
that is correct.
Okay. Wouldn't show up on his accounts though, correct?
That would be accurate. Yes,
Wow.
Do you know if this was before he became special prosecutor?
I cannot recall.
When the three of you were partners, you had at least 2 contracts to do taint work, which is filter work, and then at least 2 contracts to do first appearance work, pretty much throughout that entire 2 years, right?
Well, it renewed. So yes, I mean, if it was the same contract, but it was a renewal of the contract.
So how did you, and you said that you got these contracts through, Ms. Willis gave them to you, but it was through her knowing Mr. Wade, correct?
Willis
Yes,
to Wade to you.
I didn't have a meeting with Miss Willis. It was brought to the attention that a contract was going to be needed or awarded.
Do you want it, my man?
And if I was interested, because this was off of mine, and I said yes.
Yeah.
And so
Nice. It's a lot of money,
Mr. Wade
right? You
brought
just-
that to your attention?
he asked if I was interested in doing the contract, correct?
Yeah.
And then after that is when
Then he used your business card for his travel.
Miss Willis, would come in, or I think we actually came down here or something.
Very nice. What a
And
nice
signed the
guy
contract.
Nathan is, isn't he? What a nice guy.
And so that is how you were paid from Fulton County, these contracts.
Yes, ma'am.
And you shared your partnership, you shared a third of all your profits with Mr. Wade.
At that time, yes.
And so his contracts, he got a contract that same year, 2021, and he shared a third of all his profits with you, correct?
Yes, that should be fairly accurate.
Okay.
Fairly
So
accurate.
during 2021, 2022, you all had 2 filter taint contracts. You had
At the same
2
law firm,
first
by the
appearance
way.
contracts, and you had Mr. Wade's special counsel contracts, correct?
My firm had what I have here,
Okay.
correct?
But Mr. Campbell and Mr. Wade were part of your firm, correct?
I don't think at this time we had established
An LLC.
WBC. At this time,
A separate
I think
entity.
it was, I had mine, Chris had his, Nathan had his, and we operated in the same building. But if you ask me, did we fee share or, without everything that came in, yes, that is correct.
So the taint
So you
lawyer,
weren't actually partners, you just fee shared.
Well,
the taint lawyer and the
yes,
non-taint lawyer
at this time, we were not. I had Law Officer Terrence Bradley,
supposed to be
Chris Campbell,
separated, you know?
PC, and whatever Nathan's was, if I'm not mistaken.
So I know you said you met with Ms. Willis when you signed those contracts, right?
Yes, I know I met at least one time to sign these contracts or to sign when I signed the contracts, yes.
Did you meet with her any other times?
I did not personally meet with Ms. Willis any other time. When you say meet with, what do you mean meet with?
Talk with her, meet with her.
I mean, I would see Ms. Willis in passing if I'm walking through the office, but no, I didn't have any meetings with Ms. Willis.
After it became known that you were placed under subpoena, did you get a call from Gabe Banks?
Gabe Banks.
I did.
And was he trying to determine if you were going to be giving information in this case?
I don't know what he was trying to determine.
Yes, you do.
He
He
stated
admitted
that it was an odd, I had not spoken to Gabe in a while. We are colleagues, we are friends, we are in the same fraternity, Gabe and I. And
He admitted he
when
called
he
you.
called, it was out of the blue,
Yeah, of course.
but he did call. Yes, ma'am.
Yeah, he admitted that
And
on
you
Monday.
relayed that to me as well, correct?
I did.
And then you also got a call from your best friend who was relaying a message to you from Mr. Wade, correct?
Oh,
No, I got a call saying that he got a call, not that a message that was supposed to be relayed to me.
I'm going to check if there's a hearsay, the response will call for hearsay. Thus far, it hasn't.
Sure. So here's the objection as to the contents of the call, Ms. Merchant.
I believe the contents of the call were to remember your privilege. I took that as a threat. I think Mr. Bradley took it as a threat, and I think he would testify to that. If he took it as a threat to influence his testimony, then it's not hearsay, then it would be admissible.
All right. So
I did not take it as a threat.
Were you told to remember your privilege?
judge gave her an assist on that.
Your Honor, the witness just testified he didn't take it as a threat.
understood. I'll overrule the objection and the testimony given the weight it deserves.
Can you repeat the question?
Were you told to remember your
Your
privilege?
Honor, can we,
I was not.
the witness, there may be a potential witness now in the courtroom because the person that Ms. Merchant is referring to is sitting in the courtroom.
Well, if that witness hasn't been told to testify, then I don't see any sequestration issues.
I don't know who it is. I don't know his
All
name.
right.
Wow.
Okay.
They're there.
And so were you told anything to that effect, Mr. Bradley?
So I was not told, remember my privilege.
Somebody brought it
I
up.
do recall
Shut your mouth using the legal
privilege
word.
being mentioned, but it wasn't remember your privilege or, a threat of any sort.
It was shut your mouth, stop talking to
You called
Ashleigh.
me after.
No, I called someone else after.
You called me quickly thereafter then.
I talked to you that day. Yes, ma'am.
Amazing.
Thank you.
Amazing.
Just sit down.
So good. This dude got told to shut your mouth. Remember the privilege. He
Some
was talking.
foundation questions to begin with, please. Your testimony as you began representing Mr. Wade as his attorney on what date or what approximate date?
I didn't have an approximate date.
And give me an approximate date when you began acting as Mr. Wade's attorney.
Great question.
Maybe
Get paid?
2017, 2018, I
Oh,
think, maybe.
gosh.
Was the relationship that I asked you about just now between Mr. Wade and Ms. Willis that gave rise to the contract? Did you know about that relationship as a result of an attorney-client communication?
No, I knew of that through whatever work they did together as municipal court judges. That's
And how did you know that? Who told you about the work that they did together as municipal court judges?
Mr. Wade told me that they
Ooh, he
did
just-
work at some conference.
Okay, now, this would have been something that Mr. Wade said, according to your time period, at the time that you were representing Mr. Wade, correct?
So there is some bro talk.
Yes, but when he told me of
The
them
Fani.
being at a conference,
You had communications with Mr.
Yes.
Wade directly that
Yes.
were not attorney-client privilege, right?
Yes, bingo.
I've had conversations with Mr. Wade that were not attorney-client privilege, yes.
It
Great.
involved Ms. Willis, correct?
I just stated that they were at a conference. I don't know whether or not that involved her or not.
if Mr. Wade is telling you about Miss Willis and Mr. Wade having met at a conference, right? Then he's talking about Miss Willis, correct?
Yep.
Yes, but he also told me about other people that he met at the conference.
But he told you about Miss Willis
Yeah.
as well, correct?
I think so, yes.
So
So
that's
there were communications in which Miss Willis was at least a topic that was not covered by attorney-client privilege, correct?
This particular instance,
yes. And were there others?
I was told about a conference and
And when were you told this?
I can't remember the dates of the conference, but it would have been after the conference.
Okay, I'm trying to get just the time period here. After the conference, I want you to understand from the record, I believe we've shown that the conference was sometime in October of 2019.
Okay.
So could you give us an idea, that being a fact, when you would have had this communication about meeting with Miss Willis at the that is, Mr. Wade meeting Miss Willis at the conference?
If that's the conference that they were at, yes, then, I don't know how many municipal court conferences there are. I do know that at the time that I was in the firm, Mr. Wade, he had some position with the municipal court.
Yeah, right now, my only question is time-wise, assuming it's October of 2019, when do you tend to remember? What's your best recollection of when Mr. Wade told you about?
I can't remember because I didn't even remember that it was October 2019 until you said that.
So you don't have a present recollection?
I do not remember that, no.
Had to be before the contract, though, in January of 2021, correct?
That they met?
No, that you were told about Mr. Wade and Miss Willis meeting at the conference.
Yeah.
Had to be before.
Oh, yeah, yes, it would have been before that, yes.
I'm going to show you two text messages. Look at this text message.
Arms are crossed. Very cranky right now.
Mr. Bradley, I showed you two text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think, so, yes.
Okay. And the text messages would have been between you and Miss Merchant, correct?
Didn't see it. Yes, it should be.
Okay. And I've shown the same two to prosecution, so we're talking about the same two. In the text message, you indicated knowledge of some activity on the part of Mr. Wade, correct? And it's your testimony that the information that you imparted to Miss Merchant in these two text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade, which is we've already established as privilege.
Well, the question, he didn't get into anything. He just said, are these two text messages about privileged communications? We haven't actually.
About it, not
he's
about the
he-
communication.
I don't see an issue there.
Talking about the communication.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these two text messages, came from Mr. Wade and Mr. Wade alone? Is that
Yes,
correct?
yes.
Knowledge came from
Can you
Wade.
tell us when it was that Mr. Wade imparted this information to you?
Objection.
That's what you're going to do. And
Sure. So I'll sustain that on privilege.
And I'm going to introduce for the record when we finish these two text messages
Okay.
so that your honor has those back there. so
In
that you can-
camera.
Sure. What would they be marked as?
Okay, this is pretty good. They're fixing the prior ruling right now. Steve Sadow, this is Trump's lawyer, doing a great job. And he's not talking about what's inside the text. He's talking
I'm gonna go ahead
about the text.
The contract.
Made part of the record as defense exhibit 26, but not necessarily for its.
This is not.
Evidentiary
admitted
value.
26. It's for purposes of the court conducting the in-camera review.
Yeah.
There was
No charge.
also reference, if I remember correctly, to some email correspondence in which Miss Merchant sent you the motion that she was going to file to disqualify Miss Willis and Mr. Wade for your review. Is that correct?
Not
That's
what's
correct.
inside.
And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her in an email.
You responded by text. I'm sorry. I'm going to get it for you because
Okay.
I don't want
All
there to
right.
be any assumption.
What a baby.
I'm going to show you if I might approach. If you look at this,
Grow
does this
up.
appear to be the email that you received? It's dated January the 6th, 2024 at 10:20, can't make it as 5 or 6, 10:25
Babies.
a.m.
Yeah, I see it, the email, yes.
So
Cry
that's the
babies.
email that you received, along with obviously the attachment, which is referenced.
Yes,
Okay. And then did you respond to that email within the text message that I've just placed before you?
yes, I said looks good.
Looks good.
So the answer is yes.
Oh, yes, I did.
Okay.
Wow. Okay, so he didn't need to say looks
I'm going
good,
to mark this as
but he
another exhibit for your honor to look at.
Wow, this is painful for him. He said that Ashleigh Merchant's motion to dismiss looks good.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on a confidential or confidential communications that you had with Mr. Wade?
Yes,
So you breached that. Nicely done. So you talked to Ashleigh about your privilege. So you breached your privilege. Oh, man.
Last question. You're no longer in the same partnership or fee sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee sharing partnership, pseudo partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
And what was the reason for the partnership or the fee sharing arrangements? What caused the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I want to leave and go out on my own. Yes.
Was there any allegations made of suspected misconduct on your part?
Like
or on
you used
Mr.
your
Wade's
credit
part?
card?
That's a fairly simple question.
You know
Did
what?
he accuse you of doing anything? Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each
You
other?
know what he's asking?
We had a disagreement. Yes.
Yes.
Had that disagreement have anything to do with Miss Willis?
Oh, no,
Okay. Did it have anything to do with your conduct?
no.
Did it have
Wait,
anything to do with his conduct?
hold on, wait. So we had a disagreement, whether the disagreement was, we disagreed.
About what?
And so we dissolved, well, I left the firm.
It's a lot of work to do that.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm
You're in
simply
court.
getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged
Oh, it is privileged.
It
Why
is.
is that privileged?
because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can
Would-
take it from
It
there.
was
Were you-
furtherance of his
Did it have
divorce.
anything to do with you representing Mr. Wade in any capacity?
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Miss Willis,
As it a connection to Miss Willis, that's correct.
connected to
The divorce?
the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
For the divorce?
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the divorce? Yes, that's correct.
We'll
what this
see. That
correct
better be
means under
honest, man.
that.
The judge
You
is gonna
kinda
see
got lost
this.
on it.
You asked the question.
Did not relate to your representation.
It does relate to my representation.
In the marriage case.
It does.
It does relate to the marriage.
Whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I went and see the divorce proceeding to see Mr. Wade. I represented Mr. Wade after that, he represented me in a construction case for a time after that. And I would have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was, I don't know.
Continued representing him in connection with the divorce case after you had the separation that you've made reference to.
He continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Okay. Now,
Crazy.
Mr. Wade has testified that he did not have a relationship, a personal relationship, a romantic relationship with Miss Willis until sometime early 2022. Okay? Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, Mr. Sato, I think we've.
Would such
covered this.
information be privileged in your mind? I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to
Okay.
do. And if Your Honor says I can't, then I'm finished.
And I
If-
think this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
I don't think so,
Are you
Judge. You
sustaining what the objection would be?
That's right. It'd be sustained on privilege. to that
And of course,
question.
all the questions that we're
Reserved for the
talking
record.
about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we've talked about.
That's right.
All right, couple more questions.
All right, moving on. Mr. Cromwell.
You were asked questions, Mr. Bradley, about the circumstances under which you left the firm. Do you recall those questions?
I do.
All right. And you left the firm remained the same as far as other employees, Mr. Wade, Mr. Campbell, as the named partners of the firm. You were the one who left, correct?
That is correct.
And you termed it as a disagreement. Do you recall answering questions as though you left due to a disagreement? Yes?
Yes,
And that disagreement was that there was an allegation of sexual assault made against you, correct?
that is incorrect.
There was not an allegation that you that you sexually assaulted one of the employees in the firm.
Whoa.
Incorrect, but yes, yes.
Wow.
Yes, there was an allegation that you sexually assaulted a member of the firm, correct?
Yes, there was an allegation. Yes,
And as a result of that allegation, you left.
I did.
You were no longer business partners with Mr. Wade.
That is correct.
Wow.
The firm remained intact, and in fact, the employee involved remained with the firm, correct?
I'm not certain of that.
So Nathan's the
They
good
did
guy.
leave the building, of course.
This guy's the
um,
bad guy.
And I don't know, some of the employees did leave.
Mr. Bradley, you in fact paid that employee $20,000, correct?
That is incorrect as far as what was, no.
On or about the time that you left the firm, and on or about the time that the allegation of sexual assault was made against you, did you pay the person who had made the allegation of sexual assault any amount of money?
There was money left in an escrow that belonged to me. I don't know what that amount was.
And did that money that was left in the escrow that belonged to you, was that paid to the employee who said that you
I
sexually?
never gave any money. I left the money in the escrow account. What happened to that money? I don't know what happened to it.
For what purpose did you
Amazing.
leave the money in the escrow account when you left the firm?
There was no purpose.
If there's no connection to the money you left in the escrow account and the allegations of sexual assault that an employee of your firm made against you, why was it that you brought to my
Wow.
attention, or why'd you respond the way you did about money in an escrow account when my question was, did you pay this employee any money?
This guy's getting it
I
from
didn't
everywhere.
hand any money. It was money from an escrow account,
Wow.
to my knowledge,
Your knowledge, where did the money in the escrow account go
to the employee.
to that employee?
Yep. So this guy is getting totally screwed here. So he joined in with Nathan and the government, and they are sacrificing him to the other side.
Was there one allegation or one incident of sexual assault with this employee, Mr. Bradley, or was there more than one?
It's one incident.
Or not two?
Wow.
To my knowledge, there were not two incidents. No.
Brutal. Should have
Was there
stuck with
another occasion where
Ashleigh.
you paid any money as a result of an allegation of sexual assault against you?
No.
Did you sexually assault any clients of your firm?
No.
Never.
Never.
Who's Anna Rodriguez?
Oh my gosh.
I don't even know that name.
Oh
Don't
my.
recall a client named Anna Rodriguez?
Oh my.
Anna
gosh.
Rodriguez? No, I do not.
Never met her.
I do not recall the name Anna Rodriguez.
All right, Ms. Cross.
This clearly goes to the bias that the witness has towards Mr. Wade
Just got
and other
destroyed.
individuals, his motive in
He's like,
Okay.
involvement.
he's like,
And
I
I
just,
believe it's an appropriate
They're-
avenue to pursue based on exploring his credibility.
All right, at some point though,
burning him down.
I'm not
and well,
ready to go much further.
okay.
Oh
Judge,
my
if this
gosh.
is allowed to continue in this way, and it does appear a little bit harassing, then is Mr. Bradley going to be excused from his privilege because this is not?
That's what I was gonna do. Don't do that.
Mr. Chover.
Sit on it. I think she's
Well-
already done that.
Your Honor,
Open the
I'm
door.
asking in all seriousness, that privilege, although.
Based on the answer right now, I think now we've opened up a whole area.
Wow.
What he has just responded to, he previously said was privilege. That doesn't sound like privilege to me. We'll have to address that when we go back through the rundown. So, Ms. Cross.
I'm finished.
She's finished.
Okay.
They just botched
Mr.
that.
Sadow.
Holy moly. Oh my gosh. They just burned that dude to the ground. Honestly, he got backstabbed by the government. Unreal. This is what prosecutors
You were
do. Don't
accused
trust
by
them.
Mr. Wade of misconduct in the course of your representation of Mr. Wade, correct?
I was not accused by Mr. Wade, no.
Mr. Bradley previously testified that the reason he left the firm was totally and completely covered by privilege. To my mind, I don't see how it relates to privilege at all. And so now I'm left wondering if Mr. Bradley has been properly interpreting privilege this
Yeah.
entire time.
Yep, you have not.
And I think the only way I can cure that is by having that in-camera conversation with him.
May I suspend my redirect for you to have that conversation?
I think that makes sense. Is there anything else though that you were going to cover other than this issue?
Holy moly.
Okay.
The
Ms.
government.
Cross,
Ah!
any reactions?
Only to, Your Honor, the premise of Mr. Sadow's question was that Mr. Wade accused Mr. Bradley of the sexual assault. That was not my question. And I don't believe that's factual. Though there was an employee who accused Mr. Bradley of sexual assault.
Okay. But regardless, though, the point is that the circumstances of his departure from the firm, from what I've now heard, had nothing whatsoever to do with his representation of a divorce.
Absolutely not.
Is that fair?
Obviously.
My question, I believe the testimony has been that the circumstances of Mr. Bradley leaving the firm were related. I
can't say how much, but certainly in a large part, based on the allegation of sexual assault that was made against him by an employer.
Sure. And his previous testimony was that that was totally covered by privilege.
Yes, he lied.
Okay.
He lied. He lied on the stand.
right.
Terrence Bradley, this guy on the stand, he was, I thought, a good witness for the government. And then Anna Cross came out on cross and crossed him. Okay. Her last name is very apropos. Stabbed this dude in the back, okay? And this guy was on their team. So he then got phone calls from that other Gabe guy who was not called as a witness here in this evidentiary hearing. But Gabe also called him, and he admitted during the direct exam that he also got phone calls from other people reminding him about your privilege. Don't say anything or else you're going to get in trouble because you're covered by attorney-client privilege. And he hewed to that line. He stuck to that this entire trial.